without you, my friend. And I'll tell you all about it when I see you again. We've come a long way, from where we began. Oh, I'll tell you all about it when I see you again.
They're covering themselves.
When I see you again.
I'm here on my son who's passed away behalf and my other 3 children who have been taken away from me due to fraud. I'm basically here because I'm out of other options. I have found every bit of proof that I need to prove my innocence and to get justice.
My name is Bill Fallick. I'm an attorney. I'm based out of Gainesville. I had the opportunity to work on a case with Jonna Furman regarding termination of parental rights. It ended up going up to the First District Court of Appeal.
I'm Jean Lamblin, and I've been requested to review the documents from the deposition that I performed in January of 2015 for Jonna Furman regarding her hospitalization and the subsequent reversal of her parental rights of her children.
Hello, my name is Attorney Dan Hilbert. I'm a lawyer here in the state of Florida. I've been asked by Ms. Jonna Furman to make a statement on my perception of Florida Statute 39.806.
I am a licensed healthcare risk manager in the state of Florida, and therefore I have been reviewing the medical record.
My name is Nick Martino, and I'm a professor of law and an attorney in Florida. When looking at the overall system, the laws that I think undermine the child's interest or the absence of these laws come down to the idea that there isn't proper attorney training. There isn't an ability to challenge their effectiveness after the fact. Judges aren't even permitted under statute in most cases to hear new evidence, even if it's true, even if it exonerates the parent. And then finally, and perhaps most importantly, is that we have a system that I think in some ways values finality over accuracy. If a child is taken away from a parent and then that child is put into the system and put up for adoption, there really isn't an effective mechanism to figure out how to undo that. Undo the adoption, undo the fosterhood, and bring them back to that parent. I'm not saying it's an easy thing to figure out, but right now the system just says, oh well, you're out of luck. That is something that's bad for the kids, and it's bad for the parents, and I think overall it's bad for society. Intact parents, intact families are better for this country, are better for the state, and right now the laws in the state of Florida at least don't honor that completely. There's an issue of what's referred to as a Nelson proceeding. If an attorney that's appointed to these parents who are having their children taken away or attempting to have their children taken away, if that attorney makes an error, there's really no way for that parent to get any sort of redress. So in a standard civil case or a criminal case, if you have an attorney and that attorney doesn't do what they should have done or they make mistakes, you can go back and say that they have been ineffective and you can get another day in court. That's due process at its finest. In a termination of parental rights proceeding, although there is a right in certain instances to have an attorney appointed, there is no way to challenge the effectiveness of that attorney after the fact. So if you take that and you couple it with the idea that these attorneys oftentimes don't have the specific training they need, you have a very dangerous combination that can end up leaving a child in the hands of foster care or a different family that they maybe shouldn't have been with in the first place. And that's what I think really the change needs to happen in these dependency proceedings, is due process has to be honored, not only by effective counsel, but also by a counsel that can be challenged later if they end up being ineffective. If you can have it in a criminal proceeding and you can have it in some civil proceedings, you should be able to have it if your child is taken away from you.
I was 8.5 months pregnant on November 5th, 2012. My due date was November 25th of 2012. I got in a car accident on November 5th of 2012. I was transported to the hospital by ambulance on November 5th of 2012. It took them about an hour to do a C-section, even though according to their notes, they knew I needed one after 11 minutes of being there.
This is at 3:28, and there is not actually an incision made until 4:19.
They said the drugs in my system caused me to lose the baby, and DCF believed them. They said the drugs in my system are not medications used in a hospital setting. They lied under oath, leaving the judge no choice but to terminate my rights. It turns out I did have drugs in my system, and they do give those drugs in the hospital. When the ambulance brought me to the hospital administered those drugs to me. The hospital killed my baby and lied, having my rights terminated, so I could do nothing about it. The hospital and DCF's notes admit it.
There is an issue that occurred in the case that was fairly important. It's an issue that hasn't yet been decided by the Supreme Court. It's an issue that really needs to be decided, but what it deals with is what's called effective assistance of counsel. And what happened in her case is essentially she ended up appointed an attorney, and when it came time to go to the trial, the attorney was not prepared like he should have been.
Everybody has the right to be heard and the right to present their evidence. And as a litigator of 9 years, I can honestly say that sometimes you don't have the evidence available for you for your first day in court. It doesn't come till later.
Yes, I do believe that the delay in the emergency room and the lack of appropriate care was the final issue of the baby's demise, eventual demise.
They put their case on, and there was definitely cross-examination that could have been done, which is questioning by John's attorney, questioning of the witness to show what it was that the witness was wrong about.
The judge comes back to terminate my rights. He terminated my rights not only to my son that was neglected, but it says the judge comes back and he writes a order to terminate my rights, and it says the mother goes on to claim that the opiates must have been administered by medical personnel and has no clear answer regarding the presence of oxycodone. The records, together with common sense, indicate that no medical personnel would administer these types of narcotics to a woman who was 8+ months pregnant. While at the hospital, it was determined that as a result of damage to the placenta, an emergency C-section should be performed in order to save the unborn child. For reasons still unexplained, the mother dwelled on this decision for 6 minutes before consenting to a C-section. Not surprisingly, the child was born with profound and severe brain damage, requiring a feeding tube to sustain him. This is my name right here, Jonna Furman. Admission time 11/5. This is the same time, this day that my son was born, and this is oxycodone, and this is all of the times that they gave it to me. And more times that they gave it to me, and more times that they gave it to me, more times that they gave it to me, and more and more and more. On November 5th of 2012, oxycodone, this is a toxicology report, toxicology, oxycodone shows up as not detected. But the doctor went into the hospital and said that it was detected. He said it was in my system before I got there. So he went up there and lied. It showed up positive later on another drug test on the 17th while I was still at the hospital. But again, I did not have any of these records during the trial. I didn't know that I needed it because I didn't know that they were going to switch their story and make up more stuff. I didn't know what the hospital had yet done to my baby. I didn't know that they were the ones that caused the brain damage. I didn't know that they waited an hour to take him out. I didn't know anything. All I knew is that I was trying to save my babies. This is my son's medical record almost right after he was born. It says Furman Boy, Jonna Boy, and it's the medical record number 153-97926, birth date November 5th, 2012. And right here it shows that my son's urine drug screen was negative. So the doctor had this information, the state's attorney had this information, and the judge also had this information. I didn't have access to it at the time. I knew that I was negative of these things. I knew that I didn't do it, but they still all somehow conspired together to say that I did. Since then, I have gotten since that happened, Since they terminated my rights, my son eventually died a year and 24 days later, and I didn't get to go to his funeral. I wasn't allowed to be there. They tried to put me in jail for holding his body after he passed away. Almost 2 years went by. I didn't know if he was buried, if he was cremated. I've gone. So the head of this company who was in charge, or who was working through DCF, was Daniel for Kids, and I wrote to the president of the company, and I went and met him, and I sent him emails right here. It says, as you said yesterday, you guys get to make the recommendation. Would you be willing to sit down with my lawyer and myself instead of relying on past false information? Just look at it and see for yourself. I am begging you for help. It is not too late to do the right thing. It is my understanding that your philosophy is improving the odds for kids, and I would think to help families. Things have only gotten this far in the court system because nobody from your company has been willing to help. I am asking you as the head of your company and an educated person to please do some real investigating. He's the president of the company and said that he needed to discuss it with the vice president, and then came back and said there was nothing they could do and to get my lawyer to do something. When I woke up at the hospital from the car accident, they took me in a wheelchair to go see my baby and told me they would give me 48 hours to hold him. I told them that I wouldn't do it. I wouldn't sign. They wanted me to sign paperwork to pull the plug, and I wouldn't do it. And at first, he was only breathing 7 breaths a minute, 4 from the ventilator and 3 from himself. They gave him a 99.9999% chance of never breathing again. I stayed and I prayed with him that night. I stayed and I prayed with him that night, and he started breathing on his own. Later on, it was determined that he had an endocrine problem, which means he couldn't, the nerves in his brain wouldn't allow his body to stay warm. So I did some research and found out that it was better to have him moved to Wolfson's Children's Hospital because Shands was not able to have endocrine patients under the age of 14. When I started trying to get him moved to a different hospital, Shands called DCF on me and said that my drug use caused a placental abruption. You can see right here that DCF was not involved in my case until November 16th of 2012, which is exactly 11 days later, when I started trying to get him moved and threatening them with media. I made a Facebook page for him called Gabriel Michael James Furman, basically trying to get people to help me to get him moved. And when I did that, they opened a DCF case on me, and it says right here, this is the caseworker for DCF. It says she spoke with Dr. Tan, the child's main doctor. He explained that the mother has been acting inappropriate and rude the past few times she has come to visit the baby. The doctor allowed the FSC to read over his notes he kept from an emergency family meeting that took place on 12/10/12. A copy of the notes could not be made due to HIPAA laws. The notes explained that the mother was acting belligerent and argumentative. She was accusing the staff of lying to her. The doctors explained that the mother's drug use caused a placental abruption and severe brain damage. She also doubted the staff for sending referrals over to different hospitals. Dr. Tan explained that if the baby was moved to Wolfson's on Thursday, he will be moved on Monday. Dr. Tan explained that the baby is in need of an endocrine evaluation. The endocrinologist at Wolfson suggested by Nemours and was approved by Shands staff. Once the endocrine is established, the baby can be discharged. The FSC reiterated to Dr. Tan that the baby is not to go home with the mother, contrary to what she's been telling the doctors. The FSC also spoke with Shands social worker D. Smith, and they exchanged contact. The SW explained more about the mother's erratic behavior, including threatening calling media stations, and to get the story in the paper regarding how dissatisfied she was with Shands and how they are lying horrible doctors. The FSC assured the SW that she and all Shands staff have the right to dismiss the mother whenever she is acting inappropriately. The doctor told the caseworker that my drug use caused a placental abruption, they immediately came back and they gave me a paperwork saying that they wanted to terminate my rights, terminate my parental rights, not only to my son that I was pregnant with during the car accident, but also to my 2 older children that I had. And it says right here, these are grounds that they wanted to terminate my rights on. It says, upon arrival at the hospital, the mother refused a cesarean section for several hours, which could have prevented oxygen loss and other brain damage to the child. The hospital eventually performed the procedure against the mother's request in order to attempt to save the child's life. The child and mother were also tested positive for opiates and marijuana at the birth of the child.
They said there was a 6-minute wait because the mom couldn't make up her mind if she wanted a C-section or not. And, you know, this is kind of disturbing because, first of all, she's had a major car accident. They actually did test of her brain to see if she had any brain trauma from what it's called contra coup from the car accident, and yet they're waiting to take this baby on for 6 minutes, they say, until the mom says yes. That is not normal practice of care for that obstetrician. It is an emergency, and that baby is viable. She was 36 weeks. That baby is more than viable. And again, the marijuana did come back. The only problem I have here with this is that it came back on the detected, it was a presumptive positive. It never came back with any detectable levels of marijuana. So she could have been around somebody. Again, secondhand smoke is very common, as we know, with cigarettes. But there was never, ever a limit level, and it should have been like a D100, a D200, D300, but instead it was a positive DOA, and what that means is presumptive positive.
So I went to Shands Hospital to try to get the documentation to prove my innocence, and I couldn't afford it because it was $1 a page, and there were thousands of pages. I was in the hospital myself with a broken arm, so I couldn't afford to get the medical records at the time. They have to give you something called discovery. And in the discovery, when I was going through their discovery, I noticed right here that it says they didn't even take me to the labor and delivery room until 4:07 a.m., which is almost an hour after being there. And it says patient is now refusing a C-section from the time of 4:10 to 4:16. So I found here where it says I only refused a C-section for 6 minutes instead of several hours like they claimed before. Also, I found this. It shows my operation admission time. They took me in to operate on me at 3:17 in the morning to operate on my arm, which my arm was a trauma 1, and anytime there's a baby, I mean, my arm was a trauma 2. My baby was a trauma 1. And at 3:17, this shows my operation admission time, and it shows that the medication they gave me was morphine.
Anesthesiology. She did indeed get morphine.
So when I went back home after getting this paper from the hospital, I went home and I looked up morphine, and it said morphine was an opiate.
She got it, and morphine is an opiate.
So I took these 3 papers to my public defender, and I showed it to him. Look, you know, I didn't deny a C-section for several hours, and the opiates that you guys are saying are in my system were from the hospital. So I was happy and excited because I found a way to prove my case. I gave this to the public defender 3 days before trial. When it comes to the day of trial, they changed what they were saying. These are transcripts from my first trial. These are the actual transcripts from the trial. This is the doctor that Shands used Dr. Bruce J. McIntosh came in and spoke against me during trial.
I'm looking at Bruce McIntosh, MD. He's employed by the Baker County Clinic and medical director of the University of Florida First Coast Child Protection Team. According to this doctor, it was determined that the case, after he was delivered, had brain damage due to lack of oxygen, and that emergency C-section to deliver the baby must be done quickly as possible. I agree with that. However, this doctor is only pointing to the 6-minute delay that they state happened in the pre-op area where Ms. Furman supposedly was going to think about having a C-section, even though she had already given her verbal consent prior to this.
It says, what does the effect have on the baby if a treatment of the placental abruption is delayed? He said, if the treatment is delayed, then depending on the severity of the abruption, the baby is likely to die or suffer permanent brain injury due to lack of oxygen. Did any reports reviewed by you indicate whether there was a delay in the treatment? Yes, the records did indicate that. What was the cause of the delay, did the records indicate? The records indicate from the time of about 4:10 to 4:16 a.m., a period of 6 minutes, the mother refused to have a C-section done. So you can see right here, they went from saying several hours of me denying a C-section to 6 minutes, which I just showed my public defender. Okay? And then he says, a physician talked with her until he convinced her to allow it to be done, and then it was promptly done. It was completed within only 4 minutes. Wow. Would this 6-minute delay, would that have had a likely effect on the baby? Yes. What effect would that have had? The effect would have contributed again to the baby suffering a longer period of lack of oxygen to the brain, resulting in suffering brain damage, so it would have worsened his condition. So right here, the doctor's blaming me for the brain damage.
The patient gave verbal consent for stat cesarean section, which that should have been enough. They shouldn't have even asked her again. That should have gone forward. In my view, at 3:28, by 3:35 to 3:45 at the absolute latest, she should have had a C-section. But I know in my experience, if we're told that we have a 36, 34, whatever viable age of a fetus coming in, that trauma room would be ready. We would have called down NICU nurses. We would have had a incubator ready, and the OB, the obstetrician, would have been on call to meet us in the trauma room, and none of this happened. The thing about Shands Jacksonville, they are a trauma unit, so they should have known to have a trauma room. This is just standard of care, once again. The period of time between 3:28 and 4:10, I'm reading from my deposition that I gave in January of 2015. They said she had an emergency section. I would beg to differ with that. I would beg to differ, because that amount of time is not emergent. Urgent, it's unacceptable. They were worried about her wrist, and there was nothing being done about the baby. And they did do a cervical spine on her to make sure that she didn't have any fractures, but she was stable. She was moving all 4 limbs. That's not a priority at that point in time. 3:31, they are looking at setting her wrist. Again, nothing about the baby.
And they already knew by that time that there was something wrong. They had already found fetal heart tones that were low in the 90s or 70s.
That is correct. And the other thing was that they were more concerned about her wrist than they were about the baby. This is just not acceptable care. You can look in any Journal of American Medicine, obstetrician, emergency trauma, and you will find that the standard of care is you get the baby out. They were unable to obtain initially fetal heart tones, which right there is a huge red flag. You don't just say, oh, I can't find fetal heart tones, and you walk away. You do everything in your power. You turn the mom on her left, generally because of the superior vena cava, which is the major artery coming out of her heart, which turns the baby a little bit, so there's more blood supply getting to the baby to see if you can indeed hear heart tones. And if they fail to get them, then Then you do a ultrasound immediately. I mean, we're not talking 15 minutes, we're talking stat, which is within a minute to 2 minutes. This was not done. So it was almost as if, oh, we can't get heart tones, they just, nothing else was done for minutes. Minutes are critical for brain health of a baby, and you absolutely have to do something immediately.
And was the baby at least 36 weeks?
36 weeks it was estimated to be. But even if the baby was estimated to be 24 weeks, you would treat it the same. I have in front of me a history and physical of Ms. Furman's medical record from Shands, Jacksonville from 11/5/2012, and it shows all the different x-rays that she was given, as I said, that were inappropriate because they were not to stabilize her in any way, shape, or form. But they put down here at 328 that she was, and here's the picture of it, 328, decreased heart tones taken
you can't see it.
to labor and delivery by, here now they're saying, taken by an L&D nurse, but nowhere in the chart else is that noted. So I have a question. First of all, if it's not documented, it wasn't done, and this is the only place that it was done. So the doctor may have actually been wrong in assuming that it was an OBGYN nurse because nowhere else is it documented. SICU admission is what the plan is following C-section. Admitting service is trauma. This is at 328, and there is not actually an incision made until 419. Orange Park Medical Center had their Trauma 1, Trauma 2 license taken away because of just this, because there was not adequate documentation nor adequate response time for a patient. And remember, the baby is a patient at this point in time. So the heart rate was 90, so we know the baby's alive, and again, nothing was done. So I'm looking at it, in my opinion, in my professional opinion, I'm looking at it from the time they got a heart rate of 90, that C-section should have been emergent, whether it was in the trauma room or whether it was in OB. It doesn't matter. This is a Trauma 1 center, and they should have the people available. This didn't, this wasn't either, it wasn't as if she was taken to one hospital. It wasn't a Trauma 1, and then they had to transfer her. This hospital should have been prepared and had the doctors at the bedside. The ultrasound, 80s to 90s throughout whole exam. They make that almost sound like it is, that's a good thing. Actually, that's an extremely critical thing, that the baby's heart rate didn't have what they call decelerations to 80s, but it went back up to 120, okay? Then possibly the cord is being compressed or something of that. If you have a constant 80 to 90, that baby is in fetal demise. It's obvious that they didn't finish the narrative part of the assessment for whatever reason. But they did find it necessary to do a portable chest x-ray, which I understand. They wanted to make sure her lungs weren't crushed and that her heart didn't have blood around the sac. But at that point in time, that's the end of the x-rays in my experience. They did a forearm 2-view x-ray, they did her wrist x-ray, they did her head x-ray, they did a C-spine x-ray. All while the baby's heart rate is decreasing from 70 to 90, which is just, in my estimation, red flags are flying everywhere. Baby, 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 and they're not picking up on this. It's not clearly stated in the medical record. If they're OB, surgeons, anesthesiologists, it's assumed what their role is. We're giving the informed consent and waited an additional 6 minutes, even though they already had a verbal. Some of the concerns about the chart that I reviewed, it was well over 2,000 pages, and the problem that I had started, not only the car accident and the 20 minutes that it took for her to get there, but by the time she got to the emergency room, 20 minutes had passed, and there are no noted fetal heart tones. She was not in critical condition. She had a broken wrist, and when you are taking care of a pregnant woman greater than 20 weeks, you are considered to have 2 patients, not 1. So you stabilize the mom, and she was stable by all accounts of the medical record, and then you focus on the baby, on the fetus, and they could not find fetal heart tones. But instead of getting an obstetrician there immediately or doing any further tests, such as an ultrasound that would have shown the placenta previa that she had, most likely from the seatbelt that was under her belly, she had a placenta abrupta that had massive blood. The baby should have probably been delivered right there in the emergency room. Instead, they did x-rays of her wrist. They set her wrist in a soft cast, and the doctor didn't come for almost 20 minutes, which ultimately resulted in fetal death, which means anoxia to the brain, which also means lack of oxygen to the brain, because when there's blood between the baby and the placenta, the baby is not getting that blood into their body through the umbilical cord anymore, and virtually the baby suffocates. So you have major brain damage from that.
How does this new law work in a scenario if somebody has newly discovered evidence to disprove what was said about them before?
You know, in general, because obviously I don't want to talk about specific facts of any specific case, but in general, my concern is that through the use of potential other legal means, if a party can restrict the parent's ability to disclose any newly discovered evidence to the court, I think that really chills the parent's ability to defend themselves, because by removing this nexus requirement, the courts can honestly just look back and say, hey, look, I've already made my opinion on the prior case. I'm not going to re-review that any further, even if there's evidence potentially of fraud or any other types of abuse that were perpetrated on the court. And, you know, honestly, that it really handcuffs the judge to some degree, because they may be saying, oh, I've got to rely on this evidence. Maybe they even want to hear the evidence of fraud, but if they're saying this new law prohibits me from doing so, it really hurts the court's ability to make a determination upon all the facts. And so my concern with removal of this nexus requirement, if that is a collateral consequence of removing the nexus and prohibiting the court from hearing newly discovered evidence, potential fraud or otherwise, I really think that has a chilling effect on the due process.
They said she needed to go. They did do an ultrasound. At that point, when they did realize that the heart tones were low, sent her for a C-section. Again, like I said, we've actually delivered babies via C-section in the ER. This scenario is something that I have seen before, and for me, I was appalled that they were more concerned about her wrist than they were about the baby. Once they did get fetal heart tones, they were in what I would consider the acute phase, which was less than 100. A normal in utero baby is 140 to 160 beats. If a baby's heart rate gets down, whether they're in utero or they are a newborn, and they get between 60 to 100, you call a code. So, I mean, this is a major anomaly here that happened with this baby. The doctor writes that he visualized the ultrasound images of fetal heart rate or tracing. Well, where are they? They're not in the record, okay? The fetal heart tone you wouldn't have in there, but the tracings you would. That's the one that's on the thermal paper that I mentioned. There's nothing reassuring in here, yet they make it almost sound very positive.
So, with this documentary, what exactly are you trying to accomplish?
I want to, so basically how the law works, like, I know you guys have heard of something called your Miranda rights.
Mm-hmm.
And Miranda rights came from a woman who was like, hey, I didn't know I had the right to remain silent. So they let her go, and they said, okay, from now on we're going to read people their rights, and we're going to call it Miranda rights. Or when they first said somebody has the right to a public defender, that law was made by a man named Gideon, who was like, hey, how can I fight you guys? I can't even read or write. So they gave, the law for everybody to have a public defender. And then later on they came back and they said, well, what if my public defender didn't do anything? They didn't provide effective assistance of counsel. So they came back and said, not only do you get a public defender, but he has to prove competent, and he has to prove that he's actually working on your case, doing something for your case. That Nelson law does not exist when it comes to children. That Nelson law only exists if you are a criminal. So right now, any of you, if I were to call DCF on you just because I don't like you and accuse you of doing something, and you cannot afford an attorney, and you're in a bad place, there is a good chance that you will be given an attorney who just got out of law school yesterday and is in charge of the next 18 years of your life with your child.
Oh, I'll tell you all about it when I see you again. When I see you again.
First you both go out your way and the vibe is feeling stronger. What's small turn to a friendship turn to a bond, and that bond will never be broken, the love will never get lost. And when brotherhood come first, then the line will never be crossed. Established it on our own when that line had to be drawn, and that line is what we reach, so remember me when I'm gone. How can we not talk about family when family's all that we got? Everything I went through, you were standing there by my side, and now you gon' be with me for the last ride.
Let the light guide your way. Yeah. Hold every memory as you go, and every road you take will always lead you home. Oh, it's been a long day without you, my friend, and I'll tell you all about it when I see you again. We've come a long way from where we began. Oh, I'll tell you